Impact of Influence, the Murdaugh family murders. This is the unfolding story of a powerful South Carolina family, the mysterious deaths they are linked to, and our quest to bring you the truth. Hello, friend. I am Matt Harris. Seton Tucker's here. Dwayne, the producer, in the back. And we're so grateful that you're spending time with us on Impact of Influence. And you can find Impact of Influence on Facebook. And Seton, we touched on this in an episode because it was happening as we were recording. That is the state's response.
Right. Our last episode, we were primarily focused on the writ of prohibition filed by Alex Murdaugh's defense team. And as we were recording, or moments before we were about to record, the state's response to the motion for a new trial dropped.
And so we didn't dive into it. We didn't even have the full...
We talked... No, we did have it, but we talked about it, but just not... we had a more of a chance to really look at it, listen to a few podcasts. The lawyer, does a fantastic job. Of course, he's from the defense perspective of breaking things down, but really just had more of a chance to process.
So let's get to it. The state's response to defendant's motion for new trial and state's motions to strike. This is all, of course, about the potential Becky Hill comments made to the jury. I will actually give you the beginning of this because it's kind of important and interesting. State of South Carolina, County of Colleton, State of South Carolina v. Richard Alexander Murdaugh.
Stamped by Rebecca Hill.
Yes.
So that was interesting.
Yeah, she's stamping her own
she's mentioned
affidavit.
She's mentioned in this filing, and she's, stamping it.
So here goes. Richard Alexander Murdaugh was convicted for the murders of his wife Maggie Murdaugh and son Paul Murdaugh by a jury before this court in Colleton County on March 2nd, 2023. This court sentenced Murdaugh to consecutive sentences of life without parole on March 3rd, 2023. After filing a notice of appeal, and during the pendency of that appeal, Murdaugh filed in the Court of Appeals of South Carolina on September 5th, 2023, a motion to suspend appeal and for leave to file motion for new trial. On October 17th, 2023, the Court of Appeals granted the request to hold the appeal in abeyance, probably saying it wrong, and remanded the matter to this court to permit Murdaugh to file his motion pursuant to Rule 29B. Goes on and says other things about that. So that is about they have the Murdaugh team has the appeal, and they filed something that said, can we stay on the appeal? Can we just wait on that to find out if this first one is even going to count, right? So that's what that first kind of section's about.
Right, and then they go on to kind of talk about some of the things that were in the defense motion for a new trial. They talk about some of the affidavits. I think only one of the jurors participated actually in the deliberations. The egg juror was that 7. What's the egg juror's number?
I don't know. My paper out.
Well, she did not deliberate because she was dismissed.
That's what they not to interrupt you, but I'm just going to say it. In support of his claim, Murdaugh offers affidavits from one juror participating in deliberations. One who was removed for dishonestly concealing her own improper communications about the case. That is important. And 2 hearsay affidavits from his counsel's paralegal. Murdaugh additionally advances a sweeping conspiratorial theory about wholly irrelevant Facebook posts with scant evidence to support it. The state response as follows. I'm getting into it now. We should mention, we'll get more into it in a minute, but to explain that, why they say that one is a hearsay affidavit.
Well, Holly Miller is the paralegal for Dick Harpootlian, and she interviewed several jurors, and she did an affidavit about her communications with them, but these jurors themselves did not sign their own affidavit.
Right.
So it is a little bit confusing. Why wouldn't they sign their own affidavit?
Correct. So they section 1
hearsay.
Section 1, law and procedure. This says colorable claims of after discovered improper external influence on a jury may necessitate a judicially conducted inquiry to confirm the validity of the verdict as free from external influence through which defendant must show actual prejudice. It goes on to say that the law permits but skeptically receives motions for new trials based on after discovered evidence, after the verdict came in. And they say in their argument, and never does the law permit highly motivated convicts to put their own jury on trial. So your thoughts is, we don't have to read all of this in this section, but what stands out to you?
Well, one thing that stood out to me in this argument was that they said not every inappropriate comment by a member of the court staff to a juror rises to the level of constitutional error.
And they cite a case that was Green, and he was, I believe, was a bailiff that had made some comments. And they cite all cases, and they say, additionally, jurors are presumed to follow the law as instructed to them, to include instructions of what constitutes proper evidence to consider in deliberations, and such instructions are usually deemed to have cured the erroneous exposure to improper evidence or argument. So this is going to go into, what they're leading into is, they were told over and over again by Judge Newman to ignore any outside noise.
Every time the jury took a break, Judge Newman said, do not discuss the case.
And now, I mean, obviously the argument would be, but how much can you block out? And should it be a member of the court that is saying these things, if indeed she did say that? They did the prima facie, which is, I believe it means at first glance, showing a defendant is entitled to relief is necessary before an evidentiary hearing can be granted. That is what I think that our Lieberman and Griffin, I'm just don't know exactly what's in their mind, but they would at least want that. They don't necessarily think that everything can be tossed right away, right?
Right. They want this evidentiary hearing to look into these allegations.
And in their argument, they're saying that there's not enough, in essence, because they say it's very limited in an evidentiary hearing. They say there's three things here. Motion filed pertains to evidence typically conceived as facts, which could have been presented to a jury at trial relevant to guilt or innocent, such as would probably change the result of a new trial. And that's important, right?
That is important, because that's what they're saying is it doesn't matter if these statements were made if they didn't influence the jurors' decisions in any way.
They also say that, as part two of that, has been discovered since the trial, which I think we could say that. 3, could not, by the exercise of due diligence, have been discovered before the trial. I think didn't happen before, so. It is material to the issue of guilt or innocence. They would argue, state, that it doesn't matter. So then, okay, this is where we get to the trial court on page 5. You have there, Seton, about the following questions. Okay, these are the ones
that they think should be asked,
because this is what was asked in this Green thing, where he was a bailiff, and he made comments allegedly to the jurors, and then the judge asked the following questions. So that's what the state says whoever is going to preside over this should ask. What are they?
Yep. Was your verdict guilty on both charges, and is that still your verdict? Was your verdict based 100% on the testimony, evidence, and law presented at trial? Was the verdict influenced in any manner by communications with any bailiffs or any other person outside the 12-member jury? Did you have communication with any bailiffs or third party not part of the jury? And if so, please relay to the court what those communications were. So this is also, we need to mention why they're talking about bailiffs and all this is because this Green case that they're referencing, they're saying that this bailiff had improper communications. I think there's a little bit of a difference there, because a bailiff is not an elected official.
However, they are a member of the court, right?
They're a member of the court, but I would think a clerk of court would be held to a little bit of a higher standard than a bailiff.
Perhaps. They add on this as a footnote. In the present case, we are now many months, documentaries, and juror interviews removed from the verdict. And so the question of, is that still your verdict, is not one of probative value. So what they're saying is,
well, that's true. I mean, because after the trial was over, the jury members were free to watch, listen, go to social media, do whatever they wanted.
Right.
And so that could have changed their vote, whether consciously or subconsciously.
Although, I'm going to find as we dig into it that they're not necessarily talking about changing their vote, and Murdaugh's defense team would say it doesn't matter if they would have changed their vote or not. So they talk about the complaining juror and each juror who engaged in a final deliberation in the alleged improper communicator, in this case the clerk, with a mind to at least one, whether the communication actually occurred. All right, if so, its context and substance. 2, the number of jurors exposed to the improper communication. 3, the weight of the evidence properly before the jury. And 4, the likelihood the curative measures were effective in reducing the prejudice. So, again.
Well, and the lawyer, in his YouTube video talked about it doesn't matter if it was one juror or all jurors. It's not really, if one juror was unduly influenced, then that's all it takes is one.
Right. And he talked about, the lawyer also talked about this part of it where it says one of their arguments the state makes is that questions submitted and subject to judicial pre-approval, the court should not permit interrogation of the jurors by the parties or the attorneys. And they talk about how they did their duty and they shouldn't.
These jurors have committed 6 weeks to serving on this jury. Jury is a cornerstone of civic duty, and that this could possibly discourage other people from wanting to participate in a jury.
And I don't think that is a reasonable argument because this is so rare, one. 2, one of the things the lawyer said, the way they worded it should not permit interrogation. That sounds like there's a swinging light bulb and they're like, what did you do? But that doesn't mean you can't. He was saying, it's common to question.
Well, and we've mentioned before, if there is an evidentiary hearing, this is not open to the public. This would be conducted by either Judge Newman or whoever they deem. If they say Judge Newman is not the proper person, this will be conducted not in front of anyone other than the court staff. There won't be anybody else. You'll get transcripts, but that's it.
And I wish I could give credit to who said this, but I had heard a talking head say it could be just the judge asking questions, or they could allow attorneys to ask questions. So the evidentiary hearing, if and when we get to that, we'll have a whole bunch of questions on how that works.
Yeah, and I think an evidentiary hearing is something that does not happen often. So I think a lot of people are just guessing exactly how this may or may not proceed.
Like our guest last time, John, was talking about how a lot of this he's like, wow, we don't uncharted territory here. So Section 2, trial. At the end of the Murdaugh trial, separately sourced reports of improper discussions and social media posts were brought to the court and investigated, resulting in the excusal of juror 785, known as
the egg juror,
who now raises allegations he or she expressly denied to the court when examined. Okay, so this is the whole, and we should tell you why she's referred to as the egg juror.
Oh yeah, I think we've told people before when she was dismissed from the juror that she was asked if she had anything left in the juror room, and I guess another one of the jurors had brought in some eggs, and she said, Judge Newman said, "Well, would you like your eggs?" And she said yes. And
we're like, giggled, yeah. And so the first part of this state argument is they talk about how many times Judge Newman, they list them all. Judge Newman told the jury not to listen to any outside things. And he also instructed the jury they would only accept the evidence presented. And so they go over and over and how he said that so many times. In addition to the dozens of times the court told the jury do not discuss the case prior to the close of evidence, the court again instructed jurors, if your deliberations necessitate an overnight break, you may use these electronic devices as necessary, blah, blah, blah. So the egg jurors dismissed. And then here's what gets a little crazy. In the next part of their argument, they say that statements attributed to Hill by juror 630 resemble the ones made in court by the state.
Well, should we say, 630 also, it's really interesting. 630 has a relationship with the egg juror. She is a tenant. So there are a couple tenant relationships. There were these affidavits that were submitted by other tenants who said that the egg juror discussed the case and that's why she was dismissed. But now this juror number 630 is also a tenant of the egg juror.
Right. They're connected.
They're connected.
In small area like that, people can be connected, but that's super close connection.
She seems like she has quite the landlord business going.
And when I said the similar statements that maybe they're saying Becky said it, but maybe it was in their in its opening statements, the state said about body language, watch those closely, watch his expressions, listen to what he's saying, listen to what he's not saying, which is very similar to what 630 said that Becky Hill said.
So it's possible that 630 was misremembering where they heard these things.
That's their argument. And they also say that at the end of the initial closing argument, state implored about don't let him fool you too. And when the state, in its final closing argument, returned to the subject of body language, talking about the interview with Shelley Smith, body language is important in life. Body language, body language, body language. So they are saying, hey, these people heard this stuff, but it wasn't from Becky.
Right. It was in statements made actually by the prosecution.
So we move to the next argument. The court thoroughly investigated allegations of improper communications by juror 785, egg lady, and ultimately dismissed the juror for those communications, but gave no weight to the supposed Facebook post reported to the court by Clerk Hill in a conversation was put on record. So in the defense and Alex filing, they mentioned the Facebook thing. Judge Newman said at the time that it had nothing to do with Facebook. Remember when Egg Lady talked? So they just want to throw that out.
Well, I think that's true. We had a discussion about, I think both of us were in the court the day that the egg juror was dismissed, and how she was up there and in front of a packed courthouse.
Oh, yeah.
A large packed courthouse, and she was being questioned by the judge in front of everyone. And, he did tell her. He said that for all intents, he thought that you were
great juror.
A great juror.
But it still had to be embarrassing.
It had to be embarrassing.
And she said, if I recall correctly, she even said, does this have to do with my ex-husband, right? And he said, no, it's not to do with your ex-husband.
Right. And I'm bringing that up because another one of the arguments that has been made was that the egg juror was asked if the clerk discussed anything with her about the case or the jury. And she said, not that I'm aware of. But we said, that's a little bit, the question was by Judge Newman. She was being dismissed. Yeah. The question was, so has she, Clerk Hill, discussed the case with any of the jurors? Has the clerk discussed anything about the case with anyone on the jury? And she says, no, not that I'm aware of.
So they're going to hold that up as, well, now she's saying it was.
Now she's changed her mind.
And I think both of us are in agreement that, I don't know if it's true or not, but I do know that under those circumstances, in front of all those people, you're getting the news that you're going to be kicked off. You don't know where your eggs are.
I was embarrassed for her.
I was. Even though he said she did a great job.
Yeah.
He said you were a great juror, whatever.
But then they're not really saying that.
No, they're not saying that.
And this argument by the state is saying that she's not reputable.
They also tell in the response, they mention where she works, and that was troublesome at the beginning of the trial when someone mentioned where the people worked. They got in trouble. Why are they mentioning it in here?
I don't know.
So we go through that. The Facebook thing, you can go back and here's talking about basically a post they thought was by egg juror's ex. It wasn't by the ex. Then they couldn't even find the post, whether it existed or not. It was on something like
Walterboro.
The mouth of
Walter. I don't know what it was, but.
So you said you're not that aware of. You covered that. And we have the male tenant, juror 785's male tenant and female tenant is why they get kicked off, because they said she was discussing the case.
Right.
Even though she said to them she hadn't decided. In other words, she said nothing yet has made me say to convince them, but the trial was still going on. But John, I'd like to talk about it.
You want to read because you found this kind of funny about what they said. I think it's page 14.
Page 14.
What? Yeah. Okay. About.
Oh yeah.
When this man was making this post, what he said in his apology post. The man who was not the egg juror's husband, but the post they're referring to. What did they say?
When Clerk Hill tried to find the post again, she could not, but found another post by another account with her ex-spouse's name that apologized for deleting a post made while drunk and possessed by Satan. And after some discussion, and then they actually write in the legal thing, after some discussion about the feasibility of finding the devil-afflicted suspected ex-husband, the court said we cannot find him. And it wasn't him. It was somebody with the same name, I think.
Yes.
But the devil-afflicted suspect, it's crazy.
He admitted to taking to the bottle.
Yes. Let's see, what else? The court granted counsel her an opportunity to confront juror 785 directly with the tenant's affidavits, which the juror denied as inaccurate. You're excused. And Harpootlian says, I'm not going to argue any more about this. I'm going to defer. It's your call. It's your judgment, Your Honor. I'm not going to argue with whatever you do, okay? And the lawyer says, well, that doesn't mean that, in his opinion, that there can't be an appeal, there can't be more information that comes out, there can't be, because you're not going to fight with your judge. Try not to fight with your judge too much. They asked him, Harpootlian, do you have any problem with that? And apparently he said no, but we don't know what new stuff came out. A Judge 254 promoted from the alternate jurors. Jury never deliberated with 785 or alternate 741. And they're two of the people that are saying that Becky Hill said something.
Right, I think 741 was the alternate. Is that correct?
Yes.
Yeah, so 741 was the alternate, and she's the only remaining alternate. And I guess in Becky Hill's book, she did not have a flattering description of 741, said that she wasn't paying attention that well and that she was looking more at the gallery than she was at the witnesses who were testifying.
And so the state is going to argue that she's lashing out at Becky Hill.
Yes.
That's going to be their
argument.
argument.
I forgot to bring my Becky Hill book today.
Oh, we had it with us.
I know, because I wanted to read that one portion, but that's okay.
And then they also mentioned here that Joe McCullough is representing 630. It says, let's see. McCullough also assumed representation of juror 630 and so represents each of the jurors who provided affidavits to Murdaugh. And Joe has not allowed people he represents to be interviewed by SLED. I think he has very good reasons for that. I've talked to him about it.
Yeah, there's a lot of questions about whether SLED is the proper agency to be investigating this. I believe when Dick Harpootlian and Jim did that press conference on the steps of the Court of Appeals in South Carolina, they questioned that, and I think they may have asked the FBI to step in, but that did not happen, and SLED is investigating.
And hopefully we'll talk to Joe soon about his reasons and some of the problems he has with this state argument. So they go to state's motion to strike. The state moves to strike as inadmissible hearsay the affidavits of paralegal Holly Miller. We talked about that, how the two affidavits were not signed by the jurors. They were signed by Holly Miller, who says, yes, I did take these. Yes, this is what they said. They say that's hearsay.
Well, it does seem like hearsay, but I don't know how that works in this situation.
Yeah, and even to me,
seem like it is, but
let's say it is, then why don't they go talk to him? That's
right,
what I would say.
Right. Why doesn't... Yes, exactly.
The state moves to strike as inadmissible under Rule 606B. All such material as regards internal functions and deliberations of the jury. Murdaugh provides 4 affidavits which purport to reflect statements made by jurors, which in part pertain only to juror mental processes and interactions with one another. And jurors may not testify about what went on behind the scenes. That's they're saying is not.
That's sacred. You're not allowed to. You're not allowed to question people about deliberations.
They said exactly right. So that they throw that out. Facebook post, we talked about that. Yeah,
they say that.
From 18, read that part.
Yeah, what the part that says the state's motion to strike all materials as regards to Murdaugh's claim regarding the Facebook post, book deal, post-trial media interactions, and immaterial, impertinent, and scandalous.
I don't think that's a legal thing. You can't just say,
scandalous.
It's too scandalous for the court. We cannot have it.
Well, it was scandalous, that's for sure.
He say it's an outlandish theory that Clerk Hill deliberately fabricated the existence of a Facebook post implicating juror 75 in order to get them removed from the jury, force an outcome, and therefore profit from fame and fortune.
Yeah, and I mean, that argument does.
I don't like that
seem
argument
a little weak. I mean, Becky Hill's book is self-published, so I don't think she's not getting rich off this. She's not retiring to.
And also the argument about the Facebook post, if we're seeing that the Facebook post, Judge Newman said it had nothing to do with them being kicked off, then that should be all irrelevant.
Exactly.
This one says all facts averred in Murdaugh's motion are true. The motion fails to help make a prima facie, I hope I said it right, showing that he's entitled to an evidentiary hearing relief. They just go hard on old Alec, and I why wouldn't they? They want him in jail. They said it's an attempt to craft a breathtaking conspiracy narrative. It ultimately boils down to a single constitutional allegation. Clerk Hill told jurors not to believe defendant, therefore violating his rights to an impartial jury. And then again, they go into one juror's verdict. It's all about their argument on this part is, okay, let's assume she said something.
Right.
And they're saying it didn't have any effect.
I think this is a good time to bring up this that's been talked about a lot, just making the rounds of social media. I think Fitz News mentioned this, as well as the Presumption podcast, about this would versus could standard. So they're saying in response, just on social media, I'm sure there'll be some sort of official response, that the standard involving a court official like Becky Hill, instead of would make a difference. Like it would have definitely, if her saying these things her saying to watch body language or whatever she may or may not have said, her saying these things, it's not just would it have changed your opinion of guilt or innocent, could it have changed?
And that's a huge difference.
That's a huge difference.
So it might have, or it definitely didn't. And the argument is that, I would assume the argument is going to be, a lot of people don't know what influences them, right? You still
hard to go back to and change time and really think of where your mind was at that point in time.
Yeah, exactly right.
Well, and I think that I've noticed a lot of people mentioning on social media, people are very upset that he may get a new trial. And Fitz had a really interesting article about this, or their weekend review was really good. I really think it's not so much about the person. Like, we have to take the person, Alex Murdaugh, out of the equation. And it's more about the process and not the person.
It's all about the sanctity of the system, the sanctity of the juror's room, the sanctity of a verdict.
Because no one thinks Alex Murdaugh's a good guy.
No. But you can't have a system flawed. And I think we talked about when we had Joe on, is I hate the argument that, it's going to cost a bunch of money. Well, you've got to get things right. And you can't pay attention whether you think he did it or not, because you have to put somebody else in that thing, and it can't be about money. You have to get things right. If you're talking about somebody, let's say somebody getting a death penalty, or in this case, life, you have to make sure it's fair. They talk about juror 630, and juror 630 does not attribute their verdict to the statements of Clerk Hill, but rather, she's the one, 630 said, is the only one that was in the room.
Right.
That says,
in the state's the affidavit that the state has an affidavit from, or the defense has an affidavit.
And she said she felt pressured by other jurors, and they said, well, that's not enough to do, that has no bearing on anything.
They cite legal a case where pressure does not overturn a juror feeling pressure does not overturn a verdict.
And you can't, that has nothing to do with it,
I think we should go to this chart, though.
Yeah, let's get to the chart.
To me, that's page 21. That was really interesting. So they have this chart with the jurors that they've discussed, and they ask 3 questions of each juror. Here, remarks on evidence by Clerk Hill. The second question they ask is C, one-on-one chats by Clerk Hill with jurors. And then the last question is other concerns.
Well, and I'm looking for which interesting too, besides their answers, is they aren't the questions that they argued are the ones that should be asked.
Yes.
Early on. I've been looking for that.
Yeah, I know. That was, oh gosh, that's bad.
But yes, they earlier in their brief, they talk about these are the questions that should be asked. Look, I'm going through all my papers. These are the questions should be asked.
Yeah, here it is.
Okay.
Was your verdict guilty on both charges, and is that still your verdict? Was your verdict based based 100% on the testimony, evidence, and law presented at trial? Was your verdict influenced in any manner by the communications with any bailiffs or any other persons outside the 12-member jury? Did you have communications with any bailiffs or third party not part of the jury? And if so, relay to the court what those communications were.
So why didn't they ask those?
Right. They have these questions and they have this. So let's just kind of hit some of the highlights. What were your biggest takeaways?
Okay, so 254 is the one who says that they heard, say, watch Murdaugh's body language.
Right. Which is different than pay. So a lot of these say pay attention. But this juror 254, which is not one of the ones mentioned, says watch body language.
Mm-hmm. That's important, I would think. There was a one-on-one chat. Juror 326 said she saw a chat regarding financial and child support that someone had with Becky Hill. And
she was also given a warning about no graphic material warning, which I don't.
It's fair.
I think that to me we know for sure that there was really graphic stuff seen by those poor jurors. They won't be able to unsee.
The 544 and 589 have a problem with Harpootlian. 544 said it was warned by Counselor Harpootlian of a subpoena. They did not talk. And 589 said spouse warned by Harpootlian of a subpoena. They did not talk. And so
they didn't like. My take on that is they did not like Dick Harpootlian showing up at their doorstep.
Now the lawyer, I'm blanking because I'm tired. Lawyer, said that makes it sound like it's real pressure type thing, but he said that's not unusual to say you can talk to me now or you might do a subpoena. He doesn't think it's anything.
But I don't know how I think it might be slightly unusual for a defense attorney to show up at a juror's house.
Well,
it might be, but
he said
Dick Harpootlian's a little kind of an intimidating person, I think.
Yeah, but he said as far as general practice, he said he's done it as a defense attorney. He's gone to people and said, you can talk or I'll subpoena you.
Well, we also have juror 578 who declined to discuss the case or deliberations. I mean, that right there almost seems like you need an evidentiary hearing to find out what this juror who refuses to talk to anybody about it.
The juror 729 was the one who had the chat regarding financial support, but saw the clerk chat with others.
And they could have just been benign. She could have been asking them what their lunch order was, or if they, were having transportation problems, something along those lines.
But at least there was a person backing up a possible one-on-one conversation out of earshot of everyone else. 729 also didn't like it when Harpootlian waved the gun around.
Yeah.
And during the trial.
Juror 864, which I thought it was really interesting, that they said it was Creighton Waters in the court argument who told the jury to watch the body language. Did they think of that on their own, or did someone tell them that?
That is interesting. Because I don't know if that would dawn on me right away. But perhaps they say none of the jurors who willingly interviewed with SLED reported feeling any pressure or influence to reach their verdict. But that, again, is just the ones with SLED. It doesn't count Joe McCullough's people. It doesn't count the guy or gal who wouldn't discuss it.
Right.
The court staff, they talked about the court staff.
Yeah, and I think we should go through, Rebecca Hill had her affidavit, which was attached to this, as well as we have written statements from jury members and court staff. So let's first cover Hill's affidavit, and we talked about this briefly in our last podcast, but let's go through the highlights. They reference first her communications with juror 630. This is the one represented by Joe McCullough. And she denies lots of different things. She denies telling the jury that not to be fooled, to watch him closely, to look at his actions, to look at his movements.
Denying all this.
This should not take long. And she says that these conversations took place
with 826.
Yeah, with 826, within earshot of bailiff Bill Polk.
One of the allegations is that she talked to 826 in the bathroom. And also, one of the things that I'm taking it from the lawyer, he said that he's guessing that she probably had some help with her affidavit because she's very specific.
Well, she's represented. It's very.
And she should be, yeah.
She does, yes, because when they go on Holly Miller, the paralegal's affidavit, in regards to her conversations with juror number 741. She says, I did not have private conversations with juror 826 in a bathroom.
Very specific.
So she didn't, very specific. Did not say I didn't have conversations with them, just very specific in the bathroom.
And it's like even every single one is, I did not instruct the jury to, quote, watch him closely. Okay, but maybe she said, I'm not saying she did, but the argument would be that she can always come back and say.
Well, and another thing she says, like, during the trial, I did not tell members of the jury that the media would want to interview them at the end of the trial. So that's during the trial. So maybe it sounds like she did after the trial. During the trial, I did not hand out business cards of media personnel.
Right.
So she did. She's very specific again. And then she says she did not tell the jurors, and it's a quote from Holly Miller's affidavit, y'all are going to hear things that will throw you off. Don't let this distract or mislead you. What else?
She does all this 785 jurors. She denies all of that.
She doesn't. For example, she says she did not tell juror 785, egg juror, that she would reinstate a restraining order against her ex-husband, or that she told her that the Colleton County Sheriff's Office personnel went to her ex-husband's house. And she didn't tell juror 785 that the Murdaughs probably got to him.
Didn't fabricate nor create any Facebook post.
She didn't ask her, her opinions about Mr. Murdaugh's guilt, and she didn't tell her, well, what makes you think he's guilty?
Or forget about the guns. They'll never be seen again. That's something that 785 said she said.
Right. So basically, and she also says in regards to juror 326, which was also an affidavit from paralegal Holly Miller, she did not say that she told jurors that they were prohibited from taking a smoke break during deliberations.
Which had come up as part of the discussion by the defense team, was that they weren't letting him have smoke breaks during the deliberation, and that
was one of the reasons why they felt pressure to make, because there were six jurors who were smokers.
I like their smoke in there.
There were a lot of smokers on this jury. So then let's go through some of the statements. What did anything strike you? There were a couple that was like juror 254 found it very rewarding as a civic duty, but was told to watch his body language.
She said it says here, other than one time, we as a jury was waiting to go into the courtroom, and a comment was made to, quote, watch his body language. At that time, I didn't take it any way other than to watch his body language. That comment didn't persuade me, but it doesn't say who said it.
Right.
They heard a comment. It could have been a fellow juror. It could have been, I don't know. But that's pretty big, because 254 now is saying that they heard someone say it.
Right. And then what I thought this was a really interesting, this is a hard one to read because it was a different color, but juror 729 tells a little bit about a communication that happened after the trial. Said, on the day of sentencing, we were approached by Dateline and Miss Hill and asked if we wanted to do an interview. We told her no, and she seemed disappointed, but let it go.
Yeah, that was after, right?
That was after.
Okay. 572.
Mine are all out of order right now.
No one made me feel that I have to arrive at a quick verdict. Talks about that. And in the morning of the van that her husband told her we were going to Moselle.
Oh, and this is the one that puts they actually did not retract a juror's name on this statement. This is 572.
Yeah, I see it, yeah.
Yeah.
Name is on there. First and last.
That's a problem.
Well, it's on all of them. Wait.
No. Right here. Well, I don't want to point it out because people
I see.
I see. It's in the statement.
Yeah, she's the only one. Okay. Right. So blah, blah, blah. Some of these are hard to read, but yeah, that was the basic highlights. You've heard some of those, and the whole thing will be up on our page.
And we also had some statements from court staff. One person said that they were asked to look through social media for a post regarding a juror speaking out. But most said that they were just doing their jobs. that they were busy. And again, I think we had this conversation at the beginning of this. Not everyone saw everything. They weren't all together at the same time. Court staff, different jurors were in different places. And there seemed to be 2 jury rooms. I mean, at first we were a little bit confused if maybe this was a bathroom situation, but we ate lunch in that jury room when we filmed the oxygen special, and there's no way that all those jurors could be crammed into that one space. So I do believe that there were probably 2 separate jury rooms.
It's very possible. And at very least, you would think when they're eating lunch, say, for instance, there's no way they can spread out and eat in that little room. I wouldn't think.
And some of them are talking about there was a more chatty room and a less chatty room, and it seemed like maybe the female jurors were in the more chatty room. That does not surprise me. I would myself be in the chatty room.
I did not take the jurors on a smoke break. Said he's the bailiff, or he's one of the court staff. Let's see here. Okay, so that is that.
Yeah, well, and just a few more things before we...
A lot more things, yeah.
Yeah, well, a lot more things.
Sort of a few things.
Well, we have a change of venue in the financial trial. We have a change of venue request in Alex Murdaugh's financial trial, which is set to start the week after Thanksgiving.
He's still got 100 financial and drug-related criminal charges.
And that's supposed to be held in Beaufort. They are saying no, and there's actually a hearing on Friday of this week.
And the November 27th is the...
Yeah, to select a jury. Again, this is a little confusing to me about this whole financial trial hearing, because he's already fessed up to them in the federal court. So we're going through another trial, and now they're saying that they don't want this to happen in Beaufort because there's no way he can get a fair trial. I question if there's anywhere in South Carolina that people don't know about this case. Maybe it's worse because it's local, and a lot of the victims of his financial crimes are connected.
Yes, not necessarily that people haven't heard about it, but they may not be connected.
Right.
Talk about the unprecedented media coverage. There's 147 juror pretrial questionnaires that have been returned, stating that potential jurors have prior knowledge about Murdaugh. Aren't we mentioned in one?
Oh, yeah. I sent that to you yesterday. I don't have my phone because we're recording.
But one of the questions is, did you...
yeah, it was a lot about media coverage, and they were talked about all the different documentaries and specials, and I think our podcast was mentioned.
Yeah, did you ever listen to Impact of Influence or something like that? And so they want a change of venue, another county in the 14th Judicial Court, or can even impanel jurors from other counties in the state and transport them to Beaufort County. So better course action will be continue any and all financial crime trials for at least 1 year is what they want after the conclusion of the murder trial. They want to wait. They want to push it off a year. Apparently, and Griffin contend there's no rush to state court because he's already pled guilty in federal court. He's not going anywhere, but they also want to keep him in federal prison, right? If they could get him in federal prison.
Well, I mean, remember what John Warren said in our last episode was it'd be unlikely because he would have to be able to make bail for these financial crimes, which he could not make, before the murder charges or conviction. So it would not be likely.
So the people we talk to, and it seems to me there's going to be a ruling on Judge Newman soon, because on the 27th,
we're probably going to record this, and then we're going to pick up our phones and find out there was a ruling.
Yes,
and
yes.
And then it's outdated.
We'll jump back in and do it. So that's that. We'll keep you on top of everything as quickly as we can get it to you. We will do it. We're always super grateful, and we love the feedback, whether it's great or you tell us we suck, whatever it is, we like it. I don't know if we
don't like that.
Okay, we'll accept it.
We accept it.
Okay. Impact of Influence on Facebook. Please rate and comment on the episode. That always helps us. Share the episode with your buddies, and we'll talk soon, friend.